Hello everyone, welcome again to live session of Manu Law Classes. I will Dinesh and I will take your today's The Hindu News analysis, that is 18 April 2023 news analysis. So dear student, today I will discuss with you the most important news from your examination point of view. So now we come to the first news, that is demand for same-sex marriage recognition is urban elitist view center. So basically you may be aware about this controversy. Various petitions were filed before Supreme Court demanding the same-sex marriage. So dear students, the same-sex marriage is not recognized in our country so far, but there are different laws which deals with the different marriages. For example, if the marriage is to be solemnized between two Hindus or both parties are Hindu, then it is solemnized under the Hindu Marriage Act 1956. If the marriage is to be solemnized between two Muslims, then it is to be solemnized according to the Muslim laws. But if the marriage is to be solemnized inter-religion or inter-caste, then this marriage may be solemnized under the Special Marriage Act. Special Marriage Act 1954. So the section 4 of this Special Marriage Act, it provides that a marriage can be solemnized between two persons. Here the word persons has been used. So according to section 4, a marriage may be solemnized between two persons. Now the question arises, here the word male or female has not been used. But practically in our country, marriage is solemnized between a male and a female. Now some people challenge this view that the same-sex marriage must also be recognized in our country in pursuance of this section 4 of the Special Marriage Act, and if it is not recognized, then it amounts to the violation of their fundamental right under Article 21 of the Constitution of India, as well as it also amounts to the violation of right to equality under this Article 14 of the Constitution of India. So when the petitions were filed, then Honorable Supreme Court issued notice to the central government to ask about the reply from the central government. Now in today's news, the central government has given the reply, and according to the view of central government, that demand for same-sex marriage recognitions is urban elitist view. मतलब it is the view of the central government कि जो लोग सेम सेक्स मैरिज की डिमांड कर रहे हैं ये केवल कुछ अर्बन के एलीट क्लास लोग हैं, एंड ये और जो पूरे इंडिया है या इंडियन सोसाइटी की डिमांड नहीं है. Moreover, center has said that right to personal autonomy does not include a right for recognition of same-sex marriage. So, as per the contentions of the petitioner, that they have the right to personal autonomy. So, the view of the central government is that the right to personal autonomy does not include to the recognition of the same-sex marriage. तो मतलब अगर कोई पर्सन ये कह रहा है कि मेरे पास राइट टू पर्सनल ऑटोनॉमी है, तो इसका मतलब ये नहीं है कि वो उसके राइट टू पर्सनल ऑटोनॉमी के आधार पर राइट टू सेम सेक्स मैरिज को लीगली रिकॉग्नाइज किया जाए. फिर दिस इज द अनदर एस्पेक्ट और अनदर रेस्पॉन्स फ्रॉम द सेंट्रल गवर्नमेंट, दैट इज उन्होंने कहा है कि द डिसीजन वेदर द सेम सेक्स मैरिज शुड बी रिकॉग्नाइज्ड इन अवर कंट्री और नॉट, it should be taken by the legislature of the country, because legislature has been elected by the various people of the country. So they are the direct representative in the democracy. So if the parliament is ready to enact the law in this regard, then this decision should be left upon the parliament or the legislature of the state, and Honorable Supreme Court should not interfere in this matter. So similar view has been reiterated by Honorable Supreme Court, and Honorable Supreme Court held that the marriage is considered as an aspect of social policy of a nation across the world. It is within the remit of the appropriate legislature as the elected representative of the people to define it, recognize it and regulate it. and the choice not to recognize same-sex marriage is simply a facet of legislature policy. So means Honorable Supreme Court has held that it depends upon the discretion of the appropriate legislature that whether it wants to recognize same-sex marriage or not. So this is the present or latest information regarding this same-sex marriage. Can LG be summoned? Birla asked privilege committee. So now this news is not important, but this privilege committee is very important. So there are two kinds of privileges under the Constitution of India. One is the parliamentary privileges and second is the privileges of state legislature. Parliamentary privileges have been given under Article 105 of the Constitution of India, and the state legislature privileges have been given under Article 194 of the Constitution of India. So now the issue is that can LG be summoned by the privilege committee? It means that suppose Parliament or the state legislature both have the privileges under the Constitution of India, and if any privilege has been breached by the LG, then whether LG can be summoned by the privilege committee. So basically the privileges have been not clearly defined under the Constitution of India, and we do not find any direct answer of this question, but that the word any person has been used there, and some of the privileges are that the members will have the rights to speech. Members of both the respected house will have the right to speech only. Okay? And they will also have the right to regulate their own procedures. Okay? So now as a general view, because some privileges are enjoyed by the governor as well, and LG is one of them. So but LG, the appointment procedure of LG is different from the appointment or elected procedure of the elected member of the parliament or state legislature. So LG can be summoned by the privilege committee. So we need to have the clarification in this regard from the Honorable Supreme Court, but as a general view it can be said. Now we come next news. Tricolor on cheek, woman stopped from entering Golden Temple. So this is a issue in controversy, that a female was denied entry in the Golden Temple because she has the color of the national flag painted on her face. So, but the contention on the part of this management committee of Gurdwara is that they did not deny the entry to the woman. But if we see, if this allegation is true, then it may amount to the violation of Article 15 of the Constitution of India, because Article 15 prohibits the discrimination on the basis of this religion, race, caste, sex, place of birth. So this is the controversy. So we are not going into the controversy, but we are just going to the legal information that if any person is denied the entry in any temple or any Gurdwara, then it may amount to the violation of the fundamental right of that person. And although these directions have been given in Article 15 with respect to the state, means state cannot enact any law, okay, that takes away or abridges or that violates the fundamental right to get access into any public place like hotel, restaurant, temples. So this is the important aspect from your examination point of view. We are not going into the factual information because that is not relevant. Now we come to this editorial news. Chinese Shanghalis on Arunachal Pradesh. So basically this news is not important, but I am just giving you the basic information. You may not be asked the passage based upon this news. So basically what the China is doing, China has started renaming various places of Arunachal Pradesh, and by renaming it wants to claim that those places belong to the China. But China, we are seeing the expansion of China in the South Sea as well as on the physical boundaries. But according to the view of author, the government of India has clearly denied any possession or any sovereignty on the China on the Arunachal Pradesh or any part of the Arunachal Pradesh. But if we go to the historical perspective, so now we come to this news. While some tribes such as the Monpas, the name of this tribe may be important, have professed Buddhism, other following practice. Some tribes practice a form of Vaishnavism, the Mahabharata, Ramayana, Kalika Puran, Vishnu Puran, Yogini Puran, and the Kalidas Raghuvansam. So, if we go to the historical fact that whether Arunachal Pradesh or any part of the Arunachal Pradesh belong to China, or China is claiming falsely for all these places. So, historically, we have the historical background or historical evidences that Arunachal Pradesh was the part of the India. So here government of India has sent a clear message to the China that government of India will not compromise its sovereignty and integrity. Now we come to next, a culture of cohesion to save young lives on campuses. So basically this is also not important news from your examination point of view, but I'm just telling you about the basic concept of this news. You may be aware that various students have committed suicides in the last years in the various IITs. For example, between 2014 to 21 September, there were 120 cases in the various higher education institutions. So now these authors are telling some of the reasons about that. So mostly the people who committed suicide in these institutes belong to the SC, ST, OBC and EWS category. So this is one of the factors. So now the main concern of the suicide as provided by these author in this news is that they commit the suicide because of the pressure of study and emotional support, lack of psychiatric support. So why they are not getting all these supports? So basically when a person or when a student join these prestigious institutions, then he is pressurized with the work or the education there, and the professors do not have sufficient time to provide all other kind of supports to them apart from the academic support. So here the concern of these author is that the family members or even the institution should take care of the student there. And second point is that we should develop some medical treatment to them on the line of USA. So basically in USA they are giving more preference or they are giving more mental support to the students in their prestigious institution in comparison to India. And now they have suggested various apps such as Dost, Sathi, Mitra have also been launched to access their services anonymously. Means if a student is facing these kind of issues, then he can take the help from these various apps. For example, the names of apps are Dost, Sathi, Mitra. So anonymously वो इनकी support ले सकते हैं and they can save their life and they will not commit suicide. So now if we come to the suicide, so suicide is a attempt to suicide is a punishable offense under section 309 of IPC. So now there is a little bit change in the earlier policy and at present. So basically earlier what used to happen, if a person attempts to commit suicide, he used to be punished for 1 year imprisonment. Now, and the burden of proof was upon that person that he did not commit suicide. So suppose a person has committed suicide, then he cannot be punished because he has committed suicide or he is dead now. But if he has committed attempt to suicide, then the burden of proof used to be upon that person that he did not commit attempt to suicide. And if it was proved in the court of law that he committed attempt to suicide, then he could have been punished for 1 year imprisonment. But now there is a Mental Health Care Act. There is a Mental Health Care Act 2017. By virtue of the provisions of this act, if a person commits attempt to suicide, then it will be presumed by the honorable court that he is mentally ill and he will not be punished. and the burden of proof will be upon the prosecution or upon the police that that person is not mentally ill, and rather that person has actually committed the attempt to suicide. So now the burden of proof has been shifted from the accused person to the prosecution. Now we come to this news: hate speech. Supreme Court notice to Delhi police on plea seeking FIR against Thakur and Verma. So basically, this news may not be important, but the concept of hate speech is very important from your examination point of view. And you may be asked one passage based upon this concept of hate speech. The term hate speech has not been defined under the IPC, but there are various sections which relate to the hate speech. For example, like section 124A that defines sedition also deals with the hate speech. Section 295A means section 153AA. So 295A deals with the making such a statement which affect the religious harmony in the country. Similarly, section 153A AA provides that if a person make any statement which affect the unity and integrity of the nation, then that person will also be held liable. Now we come to the background of this news. There was a statement in a rally by Mr. Anurag Thakur that देश के गद्दारों को like this. So this statement was challenged before Honorable Supreme Court, and the trial court found that they did not commit any offense. But now the Honorable Supreme Court has issued notice to the Delhi police that they should register FIR against the concerned person. So now the question was that whether to punish these person means like MP, member of parliament, or a concerned minister, there is a need to take the prior permission of the central government. So this issue has been reiterated by Honorable Supreme Court. So basically, Honorable Supreme Court has held that the permission of central government is not required in such cases. As a general rule, section 197 of CRPC says that if a person is a public servant and anyone wants to prosecute that person for any criminal offense, then we need to take the prior permission of the central government. So Honorable Supreme Court has that in such cases the prior permission of central government is not required and the FIR can be lodged or registered against such person. Justice Joseph rescue from hearing plea against Goel's appointment. So you may be aware about this. So basically, Mr. Goel was appointed as the Chief Election Commissioner, and you know that Election Commissioner is a very important post to hold the free and fair election in our country. So the appointment of Mr. Goel was challenged before Honorable Supreme Court, and Honorable Supreme Court made a committee. At present, the President of India appoint the Election Commission, and you may be aware, President of India does all acts on the basis of aid and advice of Council of Ministers as per section Article 174 clause 1 of the Constitution of India. So now there are possibilities that appointment to this important post may not be in a transparent manner and may not be in the transparent manner. So this will affect the election or the democracy of our country. So the appointment of Mr. Goel was challenged before Honorable Supreme Court because the government appointed Mr. Goel as the Chief Election Commissioner in a very hurry manner, and I think within 24 hours he was appointed. So now Honorable Supreme Court gave the direction that appointment of Chief Election Commissioner will be made by a committee consisting of the Prime Minister, Chief Justice of India, and the leader of opposition. So these person will give the recommendation to the President, and then President will appoint the Chief Election Commissioner. So that's all for today, my dear students. I will come again with the next topic or the next Hindu analysis. Till then, thank you very much. Goodbye.